David Katz, I want to start with something. I will get right to the Stormy thing and to the Trump trial and all the rest. But the news also came this week that Judge Cannon in Florida has essentially put off indefinitely the documents trial, espionage trial associated with the Donald Trump jacked documents that ended up in Mar-a-Lago and all the other places that he took the documents. Kim asked a good question yesterday, I thought, which was obviously this judge is in the tank for Trump. Isn't there a way to replace that judge, petition for a replacement, or otherwise even impeach that judge or begin those proceedings?
You know, there really isn't, Mark. One of the things of our federal system was to try to make these judges kings and queens. The idea was that then they would stand up to the government and stand up to the big, powerful interests in society. Some people think that a lot of times they roll over for the government, especially in criminal cases, and roll over to powerful, corporations. But the idea is to really give them that independence. And so to try to remove a particular judge, they're supposed to be randomly selected. We've talked about the fact that they try to judge shop, and that even the judicial conference, which is part of the judiciary, part of that branch of government, has decided to do something about it. And McConnell from the Senate was screaming that, hey, we pick these judges all around the country in places like Amarillo and Fort Pierce. You're not letting my black magic work, McConnell says, you judicial conference. But they're making it harder to judge shop. And there certainly are some reasons to think that this case was judge shopped to her by Trump because he ran up the road to complain about the search warrant that was done at Mar-a-Lago. That was being done by a magistrate judge who was not her. And then she stuck her big hand right over that case, got reversed twice with unprecedented, weird rulings. She got reversed by the Trump-appointed, very conservative 11th Circuit. And now the idea is that she's walking on thin ice. But, and we've talked about this ad nauseum, that special prosecutor Smith brought the case down there, and he had a 1 in 3 chance of getting her, and he got her. And really and truly, now he's stuck with her unless one of two things probably happens. She makes a ruling which he can appeal to the 11th Circuit, and as part of the reversal, he says, you're just going to send this case back to the same judge who's biased against our position. I could show it to this court, and the court will say, you know what, we are concerned about the bias of this judge, and so we're remanding it, but to a different judge. That's unusual in the federal system, and she has not given him any real raw meat that he can show third strike and she's out. She had these two other rulings she reversed, and by not ruling, she's kind of preventing him from some appeal. Now, he can also bring what's called a writ of mandate, where you say, this is an extraordinary situation that just has to be cured. Here's all the reasons why it's extraordinary. Maybe he had a shot at that to try to get the case to trial before the election. But where he is right now, none of it's going to be effective, Mark. And one thing, whether she's done it in a Machiavellian way or she's just really slow because she's not used to these kinds of issues, or a combination of those things, but the reality is she's left 7 or 8 key pretrial rulings hanging. Even if the case were now remanded and sent to a different judge, they'd have to get through those 7 or 8 rulings. They may involve evidentiary matters. Of course, Trump will try to figure out some way that one of them involves presidential immunity. It involves something. When he took them from Washington, D.C. on January 19th, when he was still president, that was presidential immunity. They're trampling on it. He wants to go back to the U.S. Supreme Court. So he's got lots and lots of ways he could have delayed this case. And for all I know, he could have delayed it in Washington, D.C. But we've talked about the fact that it sure seemed like it ought to have been brought in Washington, D.C. There was venue in Washington, D.C. If his great desire was to convict these other two, he could have charged the two of them in Washington, D.C. I believe that as part of that conspiracy, they knew and that overt acts were being done in Washington, D.C. They would have made their motion to the judge in Washington, D.C. Hey, change my venue down to Southern Florida. They would have won or lost. In my experience, I think they would have lost. Their appeal, I believe, would have lost. And if they were ultimately right, a jury has to find beyond a reasonable doubt as to those two that there's venue, as well as the other elements of the crime, Mark, that there's venue. So they might have gotten acquittal. You know what? If they'd have convicted Trump before the election of the documents case, the Mar-a-Lago case brought in Washington, D.C., and not convicted Nauta and the other guy, you know what I mean? I could have lived with that, Mark. Mark, I really could have lived with that.
What if I were to hire David Katz as my attorney because I get the friends and family discount probably.
You do.
And thank you. Thank you. And I were to say, I want to sue Judge Cannon for incompetence, negligence, and a miscarriage of justice.
Well, you don't have standing with the court to do that anyway.
I'm a member of the public, and it was my document that he flicked around at the Mar-a-Lago.
Oh, that's good. Kim is a provocative question.
There were a few judges in the Central District of California, now deceased. They would have made you a millionaire if you could have sued on that basis.
No, bad case. You're not taking the case? No.
And the reality is, judges have immunity. There is nothing that criminal defendant and some other people would like more in life than to sue the judge and the prosecutor on their case until hell freezes over, right? And you just really can't allow that. They have not just qualified immunity, but they have immunity. So very, very difficult. And saying someone's incompetent, saying that they're biased, they would say there's a system that's set up to do that. So you just wouldn't get anywhere. Now, if they waved around your document, okay, that's kind of sensitive because it's really unlikely to involve an individual. I mean, those things were much more than some, individual. They were plans to invade, Iran in the contingency of war with Iran. Think about that, right? And he's waving that around. I'm not the guy who came up with this plan to invade Iran by going this particular route. That was the Joint Chiefs of Staff. And now he's trying to lay that off on me that I was willing to kill all those people. They would have killed more people this way. And he's talking about the route that we would take if we were actually going to invade Iran, if we were going to, and it's not hypothetical. We're in the Middle East right now. There's the whole thing with Gaza. There's the whole thing with invasions. We have all that stuff analyzed, thought about. For him to be waving those things around are kind of outrageous. So I guess you could, somebody acts on that, you find that it leaked, but at the same time, they're so careful not to have it known that it leaked. They don't want it known that maybe something leaked out. There was that thing where Trump was first in the White House in 2017, and he let all of those Russians run around in the Oval Office, and our own national security people weren't there, and all of the, what Reagan would have called the evil emperors. All the evil emperors were right there in the Oval Office with Trump, and it looked like they were looking around and stuff like that. And soon after that, it turned out we had somebody really near Putin, who was like in Putin's inner staff. And apparently we removed that person from Putin's inner staff right away because the national security people were worried that that's one of the things that they'd peeked at or they'd gotten, from Trump. So there's huge concerns about that, but they want it not to be known. So even if somehow you were prejudiced, Kim, you can imagine some hypothetical, they would have taken great pains that you wouldn't know about it.
Oh, wow. It's not the only, and I will get to Stormy Daniels and everything today, but it's not the only. It's not the only case that involves a question about a judge. The Georgia case, or I shouldn't say officer of the court, might be a better way to put it. The Georgia case is associated with the Fani Willis questions that are associated with her relationship that she had with the prosecutor, someone in the office. Now, you can speak to this better than I can, but essentially the Trump people are petitioning the court saying, hey, because of this relationship that Fani Willis had with another guy in the office, this entire case needs to be called into question and, sort of hit the reset button on it. Isn't that essentially what's being said? And now that an appeals court is actually going to listen to that.
Well, apparently there's some discretion whether they take the appeal. It's an awfully high-profile case. It's probably better that it be decided, Mark, by the Court of Appeals. That's a state court of appeals. Someone I think had said in your chat that it's going to go to the same court that the Judge Cannon matters go to. No, the Judge Cannon matters go to the federal appellate court. This one's going to the state appellate courts because it's a local prosecution. Probably better to have it decided right now. If Fani Willis ought to be recused from the case, we don't want to find that out after there's been a final conviction, and then it's a basis to set the whole thing aside like Harvey Weinstein's. Probably better to know and have that decided now. And I've said for quite a while right now, I just don't see this case going to trial, especially on Trump before the election. So in that sense, what difference does it make if they take the case now, decide it now? I think their decision, Katz, is going to be that they're not going to remove the office. I think that judge there, who I think is a Republican, who ruled in that case, seems like a very, real straight arrow, said, look, it was not a smart thing to do. The optics of it were really bad, but I don't think it's grounds to disqualify the whole office. And they really haven't shown anything that she did that a non-conflicted prosecutor would have done. She has to show prejudice. She has to show an actual, I'm sorry, Trump has to show prejudice. He has to show an actual conflict of interest. And especially with the boyfriend, that was really bad optics. I mean, he got $700,000 from that case. He was her boyfriend. At what point didn't really matter to a lot of people. They should have exercised a whole lot better judgment than that. Having said that, the case is about Trump and interfering.
Thank you. I didn't understand how it bleeds over into the Trump case at all.
And trying to steal the election. This is the one where what they don't have in the New York City trial, they have a tape. They have him calling into Atlanta, remember calling into Raffensperger and saying, find me 11,000 more votes. And he didn't mean find them by legitimate means. He meant concoct them. And the count had already been done 2 or 3 times by then. I think there'd even been a hand recount by then. There was nothing more to find. What Trump was saying was, make the election come out my way, even though I lost it. And you have that tape right there. You have an awful lot of evidence. All I can say about it is that knowing all of that, Mark, she could have avoided all of those problems. And it's ironic how it turned out, because the former governor, a Republican of Georgia, was really their first choice. And that boyfriend was the head of the search committee, and he didn't want to do it. And it's all the ironies of this case. What's the real reason he didn't want to do it? Because Trump is such a threatening person. The tweets he sends out, the menace that surrounds it. He said, look, I don't need it at this stage in my life to have a bodyguard the rest of my life. Other than that, had Trump been a normal person, a normal political actor, I mean, isn't that ironic? Isn't that sort of the wrong lesson? That probably that Republican governor would have taken on the job as special prosecutor, and we would have been spared all this Fawny and her boyfriend stuff. But we are where we are, and I think they're going to allow the case to go forward in the state court down there with Fawny. I've said for a long time, Fawny should not be the decision maker. She should run that office and not run this case, and put people who are totally independent. And at least she can argue in the court of public opinion, I had nothing to do with it, whatever, and mean it. Get out of it. Have her top deputies make all the decisions in the case.
That said, that case doesn't get done before the election, right?
No way.
Yeah.
Not against Trump.
Yeah, exactly.
Remember, there's lots of other players. There's lots of other players, but they're not.
Right, but you know. Right. So we're left with the only case that will actually get done before the election, and that looks like the case that's being prosecuted now in Manhattan. And so that's the case involving Stormy Daniels, involving the bookkeeping world of Donald Trump, involving payoffs, et cetera. Bring us up to speed. I was saying in the first hour that the Stormy Daniels part of this, while salacious and juicy, and after you've watched a bunch of accountants speak about things, listening to he was wearing silk this and a T-shirt, and I came out. I mean, all of a sudden, things get really interesting. But apart from that, David, she's just establishing as a witness that something happened. It's all really about the payoff, isn't it?
Legally, it doesn't matter whether something happened or it didn't happen. Legally, it doesn't matter whether he had, for this case, it doesn't matter whether he had leading to coercive sex with her, which she wanted to imply, had totally consensual sexual intercourse with her or not, or nothing happened in that room except he was a perfect gentleman. The point is that she claimed that they had had sexual intercourse in that room and that she was going to blab that a couple of weeks before the election. She took $130,000 not to blab that. No one that mattered knew about it. It was since something 10 years before that no one paid attention to. But that it didn't become a bombshell in the 2 weeks right before the election. Him and Hillary in 2016, he'd already had the Access Hollywood tape come out and really damage him in the eyes of suburban women and other people who were swing voters in that election. This would have been a disaster for his campaign had it come out. I subscribe to the narrative that this was done as felony conduct with the idea of paying her hush money and then covering it up with the false business records so that she would not hurt his election chances. He said later on, I mean, I think everyone recognized this too. I think Hope Hicks, he said, thank God this didn't come out during the election because that would have been like a killer. That's a fair, but there are actually some triable issues in the case. But having said that, Mark, that it doesn't matter legally, it matters an awful lot to the jurors sitting there. Not so much jury nullification. not everything else. But just ask yourself this: if you're a fair-minded juror there and you're trying to follow the instructions, but you're also a human being, if you believe that Trump was a perfect gentleman, nothing happened in that room over 15 years ago, and she comes along 2 or 3 weeks before the election, and she's going to tell the story that they had sex in there and everything the way that she ended up telling the story on the stand just now. He's so freaked out. He agrees to succumb to the embezzlement. This blackmail is out there. He wants to pay her cash in some alley somewhere and hope that she'll actually keep her word and shut up until the election is over. And then Michael Cohen does all this stuff, and the whole thing just, everything's happening so fast. Everything freaks him out. It would matter if you thought it happened just the way she just said it did on direct examination in the trial, or if you thought that Trump really was a perfect gentleman and no sex happened and she's an extortionist who made this up. And that is why they're into this whole game, because it really does matter to what a reasonable jury is going to think that the prosecution wanted to put on this show and risk probably a mistrial. We can get into that for a second, and why Trump has to come back. Trump couldn't stipulate to the testimony. There were certain things in there that the prosecution really want that really hurt him. And his own lawyers said, you know what, we'll make hay out of some of that stuff, because they could have constricted it more. They could have put more guardrails on. They could have said, before we get rocking and rolling on this, we don't want there to be circumscribed testimony, Your Honor. We, the Trump attorneys, want to know, Your Honor, what exactly does that mean? Let's do a little dry run. What exactly is she going to say was said in that hotel room? What exactly is she going to say happened with how the movements, where the sex took place and all that kind of stuff? They didn't have those kind of guardrails going in. And then she expanded, she gave speeches. They didn't stop that. And that is why when they moved for a mistrial, they said, no, 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 don't play me, defense attorneys. Okay, you asked for this. You could have objected. You could have made sure what the guardrails were. You didn't do it. Let me just give you one example, Mark, if I can.
Please, this is fascinating. And by the way, I've heard in a trial that has been dissected every which way and x-rayed every which way and analyzed every which way, I have not heard what you're hearing right now on this. So please go right ahead, David.
Well, you know, so much of it is political spin. I mean, it probably is going to have an impact on the election. These things that are happening right now. I would think, I'm not a political commentator, but I would think that this whole salacious display, the fact that she held up pretty well on the stand, I think that most people who paid attention thought it really did happen. The way she says, pretty much, and Trump said the things that she said that he said. I think the first reaction that people who don't pay a lot of attention, the swing voters out there, I think it hurts Trump. So I think that, you know, a lot of it goes through that prism. And, you know, like MSNBC is just triumphant about everything that happens. And, you know, it just seems to be sort of a lack of analysis. And there's a lack of analysis, you know, on the other side of it, too. She's a huge liar, so the case is down the tubes. Well, like I said, whether she's a liar or not, whether sex happened or not, it's about the cover up. But anyway, let me give you a couple of examples.
Give me the example, though. Yes, please.
He supposedly says that, oh, one thing I like about you so much, Stormy, as she's in the hotel room, he's in his pajamas. She's come up there the first time they've ever met. She's meeting a man in his hotel room suite. Okay. So he says, you know, one thing I like about you is you're so smart, Stormy, and you remind me so much of my daughter. Now, come on. I mean, these two hate each other. Trump doesn't want that sitting out there. That feeds into that whole narrative about Trump, you know, the one. So he's got to call her a liar, because they're going to press that forward, and he's going to call her a liar. She says that Trump says to her, obviously to woo her, that, you know, Melania and I, we don't even sleep in the same bedroom. Well, that's not good for Trump. I mean, it makes it look kind of like, you know, this thing is a sham. It's a marriage of convenience. You know, all these things. She wanted to get a green card for her relatives more than she wanted anything else out of Trump. The whole narrative of the Melania-Trump transactional marriage, that doesn't help very much either, does it? But let me give you another example. She says, for instance, that we had sexual intercourse without him using a condom. He knew that she was a porn star who has sex with people, different people, random people, as the script and as her employment demands, all the time. Trump is going to argue she's a liar. I don't care how horny I would have been. There is no way I would have had sexual intercourse without a condom with someone who did porn all the time. No way. Didn't happen. If her story had been that something sexual went on, but I was not about to have sexual intercourse with her like that without a condom. So he is going to, you see, the fact that he could have kept that out. He could have absolutely, his lawyers could have said, if they're going to get into all that kind of stuff. In fact, they were getting into the positions. They were getting into the, excuse my saying so, I don't mean the pun. They were getting into the missionary position in court when the judge said, stop, stop. You say circumscribed. This is well beyond what I thought was going to be circumscribed. The judge actually had to stop it. The defense attorneys did not jump up when that started. Now, the defense attorneys will say in their spin, if we had objected so much, it would have looked like we were hiding something. We would have looked bad in front of the jury. But the way that you do that is you have a sidebar. You have a conference with the judge and say, look, let's set out the guideposts right here. And then these smart criminal defense attorneys, they would have been in contempt. They would have known very well where the guideposts were. And the prosecutor would have known, because the prosecutor, she went very up to the edge too. This was an interesting one. They were both women on both sides, and they were both named Susans. This is like, you have me and David K. Johnson. Remember a couple of nights we've had the two Davids? Yes. This trial had the two Susans. It had the two Susans.
This is fascinating because, again, I've not really heard a drill down on this particular part of the angle that the defense might have taken. And because of the reputational damage potentially that you've sort of alluded to, which is that, the Melania relationship, the kind of sex they had, et cetera, I'm wondering just how the defense felt this was something that they wanted to allow in. Why? Is that an unforced error, essentially, that the defense did not exclude this kind of testimony that we've heard about the specifics, the concocted or real specifics of the actual sexual encounter?
Well, at some point, Mark, if it's bad enough and it's prejudicial enough, a court of appeals might have a different view of this, and so they might reverse. And the defense attorneys are trying to. You remember in OJ, they had Dershowitz as their appellate attorney. It's like, we're not at the appeal stage, dudes. We're at the trial stage. But what Dershowitz was doing was looking for appellate issues, telling the trial attorneys, present it this way. Make sure you make the objection. Make an offer of proof. Show why you're being prejudiced, so that you can set up the argument for appeal. So it's been dealt with below, because basically if you don't object in the trial court and object properly, and even object on the proper basis, they'll say you haven't preserved it for appeal. So the appeals court is not a lightning round of brainstorms about things that should have happened at the trial. It's a review of errors by the trial judge. So you have to make the right objection and present the right thing so that the judge can either get it right or err, and then you can complain about the errors. But what you haven't raised or haven't raised properly. And so they were trying to, walk that fine line. They've gotten millions of dollars for this defense. But, there are some interesting things, like she says that she's impoverished and, poor me is kind of the way she presented herself, especially during the direct examination. Her book was worth $800,000, supposedly. One of her fights with Avenatti was that she got a chunk of change for her book. And one of the allegations in one of the federal criminal cases is that Avenatti committed fraud against her. Well,
he kept the money.
Because he kept the money, right. But it was about $800,000 that they were talking about. She also has said that there was an incident. This all happened like 2006. It's a long time ago. 2011, like 4 or 5 years later, some guy comes up to her in a parking lot, according to her testimony under oath, and says, she's with her baby, and says, wow, you have a really beautiful baby, Miss Daniels. And terrible if something happened to your beautiful baby. That's like right out of, film noir. That's exactly the spiel that the thug gives, right? The person clams up after that. Well, so there's a father, right, of this kid. She never tells the father. That is pretty good cross-examination. If you believe that she made up that story to generate sympathy, then you're ready to believe, if you're a juror, that maybe she made up other stories. And we have a saying, it's a legal maxim, that if you lie about one thing, the jury can consider that you lied about everything. So that, the poor me, and yet it's worth $800,000. And they said to her, look, you basically made a whole lot of money out of this incident. And she says, yeah, Trump also made a whole lot of money out of the publicity he gets. Today, she was a little better today. It's funny because there were 2 days, and you would think that the defense would gain, having heard what she has to say on direct examination and having a day and a half to prepare. Any defense attorney would love that. A lot of times it happens really fast. Cross-examination is a really tough skill. I think I'm very good at it, but it's a tough skill, and you got to know the record so well because you can't say, wait just a second. Didn't you say on, where is that document? Can you find me number 722? Hang on just a second. Hang on just a second. You know, a cross-examination like that, it loses its whole thrust. So you got to really know the record well. I think the prosecutor did. And Stormy knew the record well. I mean, one thing about Stormy Daniel is that, you know, she sees herself as a very intelligent, very well-spoken person. Like so many people in LA, she didn't really want to be in porno flicks. She wanted to direct, Mark. This poor woman, she wanted to direct. Yeah. And she sees herself as a writer, as a very creative person. In fact, one of the, you know, she has told people previously that she and Trump did not have sex. That's obviously more great impeachment, more great cross-examination of her. Now you say on the stand under oath that you had sex with him. You've told other people that you didn't have sex with him. How is that? And I think part of her story is that the NDA was kind of hard to understand, the non-disclosure agreement. She was under obligation not to say things, so she didn't say them in observance of that. It would confuse, you know, even a non-legally trained intelligent person. It would confuse them. That was the redirect. That basically it wasn't the NDA kind of complicated and making sure you complied with the NDA and you had other reasons not to tell some people. You don't just run around and say whether you did or didn't have sex. Maybe you say somebody's bothering you. You don't like the way they're questioning you. You don't like the whole situation. You say, no, I didn't have sex. Leave me alone. I didn't have sex. So it was more flippant when she said that she didn't have sex. It wasn't well considered. And also she was confused by the NDA. So she should have said, sure, I was confused by the NDA, but she's very proud. So she wanted to, you know, in the redirect, she wanted to, no, it didn't confuse me. No, I can read it. I'm a very smart person. So it was fascinating. I think on balance, I think the prosecution felt they had to go there. They can't take the chance from their point of view of this being a not guilty mark. And they figure that she strengthens their hand. One last thing, the defense says they're going to make another motion for mistrial. And I'm not sure what the basis is going to be. And there's apparently a big dispute whether McDougal should be allowed to testify at all. But it seems to me that if the prosecution wants to call her and there's anything relevant that she has to say, you know, everybody has to give, this is America. Everybody has to be a witness unless they have a privilege.
It's interesting to me, though, David, that as we said, this is one page in the book of prosecution. And what we also heard was from the comptroller at Trump, the Trump organization. The Cohen stuff. In other words, the trail of money was the other thing that we were hearing about. In your judgment, as we sort of wrap up, do you have a sense of you've made frankly a very compelling case? Just generally, it's something I hadn't considered, which is there's a lot here that could live on appeal. But let's just talk about the case before it gets to appeal. Has the prosecution done a pretty good job of creating the trail and the connection between the payoffs and the political damage that they were trying to avoid?
I think they've done an excellent job, Mark. You have to remember that this is a case that the U.S. Attorney's Office, not under just Trump and Barr, but under Merrick Garland and the U.S. Attorney that was picked by Biden, declined this case. They decided not to go on this case. It may be because they saw January 6th was coming and they wanted to save their fire federally for something they considered that important. But you know, this is a difficult case, and the reason it's especially difficult in state court is that to bump it up to a felony, they have to show that Trump knew and intended to violate state or federal campaign law. If all they show is a violation of federal law was in Trump's mind, that's a potential issue on appeal. Will this state vessel carry felony weight when all that's on board it is a federally oriented intention by Trump? It sounds like inside baseball, but that's another appeal issue. What they'd like to show is that he intended to violate state campaign law. He's in state court with a state felony violation because he violated state campaign financing law. Michael Cohen will say, I explained that to him chapter and verse. We discussed that. He knew about it. Here are my notes. Here's my everything. And so the huge impeachment is to impeach Cohen on that. If they don't believe Cohen on that point, that Trump ever knew that this was a violation, and he likely heard that from Cohen. He wouldn't have heard it from a non-attorney, and all these other people in the mix are kind of non-attorneys. Then I think Trump has a chance of either having a hung jury or actually being acquitted of the felony. I think he's doomed on the misdemeanor, but I've said this before, his characterization will be they spent all this money, they spent all this time, they made me sit here with the election interference of not campaigning, although he's probably getting more publicity here than he ever would have gotten in any campaign appearance, but that'll be his story. And what did they basically do? They gave me a bunch of traffic tickets. That'll be his spin on if it's only misdemeanors. So I think that they're in the hunt. And I heard one commentarist say that they should have only say there's one liar in a case. Michael Cohen has to be the liar. If Michael Cohen's a liar and also Stormy Daniels a liar, after a while people think, no, your side's the liar because too many people lying. But I didn't agree with that because I thought they had to go after, not just reputationally, but because if people think that Stormy is that he had sex with her and that all those things were said in the room, I think that looks really bad. People say, well, yes, she wasn't an extortionist. She was someone who had a claim. She was willing to hush up, but she had a valid claim. If they think she was just an extortionist with wild blackmail that she pulled out of nowhere, I think they'd have a different feeling toward the case, whether the jury instructions tell them that or otherwise. I think rational jurors would have a different feeling toward the case if they thought that this was made up out of whole cloth as an extortion attempt by this porn actress who's just mad for money and is willing to tear him down to get some money and make stuff up just to get some money. They don't want the jury to think that. And that's why the prosecutor went where they went. And that's why Trump had to call her a liar and put on this huge tear down of her.
The last question, David Katz, is about something that you just sort of referenced along the way, and that is Trump told about this by Michael Cohen. If he wasn't, might that then open the door to just it being a misdemeanor? So you're saying that Trump, the candidate, can authorize these payoffs to avoid this information getting out, put aside whether or not the sex act actually happened, just the information, the smear would be out there. Trump, the candidate, can write those checks or authorize those checks to be written, that deal to be made. And if he didn't know that it was a violation of state and federal statutes, then he can't be held to account for it. Is that true or false?
As a felony in the state court. In the federal court, the level of proof would have been different. But the case that's most analogous federally is probably John Edwards's case, where it's a little complicated, even how the statute works federally. This state statute is even more complicated. But even the federal statute is a little complicated, has a lot of jury instructions. It ended up that John Edwards had a hung jury, and then the federal government decided not to pursue the case after that. By the way, I do think that there was some other very compelling testimony if I were on the jury. I mean, the fact that Trump is such a micromanager makes it much more likely that, and Cohen will have things to back him up. There are ledgers that kind of back him up, but the reasonable doubt will be, the theory that his lawyers will try to push is that he didn't want his wife to find out about this. This was really the main motivation for him. He wanted to start the presidency clean. There was enough dispute about everything, him coming to power, Obama being out, him having a 10% chance of winning his win. He wanted to come to the presidency kind of clean. He wanted to put this behind him. But remember, he's the one who signed the checks. He's not, you would imagine that Trump wouldn't have signed those checks. Somebody prepared those checks, put them in front of him. He signed those checks. They do say legal expenses. People have to be very careful. Legal fees would be worse for him. They said legal expenses. He'll have an argument that this was, at least in his mind, kind of a legal expense. Michael Cohen had handled this whole thing. There was a lot of lawyering involved in it. He was paying for legal expenses. Some of it was Michael Cohen's fees. This is going to be a big brouhaha before it's over.
But to put a fine point on it, David Katz, I always hear, ignorance of the law is no excuse. Is it an excuse or not?
It's an excuse here because you have to have a specific intent, Mark. You have to have specifically intend for the felony to know and intend to violate campaign finance laws, state and or federal. And they'll present that theory. That's what Michael Cohen is going to say. He's going to say that he wanted to pay cash, and that's why he wanted to pay cash. Cohen had another way to handle it. Of course, Cohen's way, they're going to say, put more money in Cohen's pocket than any other way. Trump's going to say, wow, he was a lawyer. I thought he came up with something that was legally appropriate. I didn't think this guy was going to lose his bar license. He'd worked for me for years. He never lost his bar license. Why would I think he was going to lose his bar license and commit felony conduct over this thing? He went off and did his thing. I went off and did the last 2 weeks of the campaign. I was distracted with an awful lot of other things. It's going to be a big brouhaha. And of course, the criminal defense attorney in me, come on, how can I not be fascinated with all of this?
Oh, my God. I mean, this has to be like eating caviar for breakfast for you guys. I mean, who are in the legal game, and you're at the top of the legal game. David, so appreciate the time. And there's a lot here. The whole questioning of Stormy Daniels you put it in a much different context than anyone I've heard talking about this case. So if you're just joining us, I encourage you to go back, and we'll drop this as a separate video as well. Thank you for being here. Really look forward to these conversations, and I always learn a lot. And there he is, Katz, and he actually was impressed. David indicating he was impressed with the case that the prosecutors have brought so far. Are you ready to make a prediction, or you want to wait until next week?
I think it's a difficult case on the felony, and I'm just really not sure which one. I think he gets convicted of the misdemeanors.
Of the misdemeanor, yeah.
I think it's also possible. I think it's also possible that it's a hung jury, although I don't think that's very likely. You know, a lot of the speculation when I was on radio in London, they think, oh my God, how can these 12 jurors possibly get this right? They're all Democrats. They're all from New York City. But I don't know, Mark. Ask yourself this question. I think you and I could be, you and I and Kim, I think, could be pretty fair jurors. I mean, we'd follow the instructions. We'd take it seriously. Beyond a reasonable doubt, it's a high standard. And I think that's what the jurors are going to do there. And, you know, just how much they can really hit that mark with, excuse me, by using mark, they can hit that goal with Michael Cohen. I mean, Michael Cohen is just going to be, he's going to be impeached so much. And, you know, there are things that these witnesses say which are amazing, which is that, you know, he entered a guilty plea, but he lied to the federal judge. That's Michael Cohen. Michael Cohen, I lied to the federal judge when I said under oath that I had committed these 3 felony violations. I hadn't done one of them, and I lied to the federal judge. But, you know, Stormy said, yeah, I've got a $600,000 judgment that I have to pay Trump, and it's all Avenatti's fault. And to the extent it's my fault, I'll never pay him. And if a judge orders me to do it, I'll go to jail first. I'll defy the order. You're supposed to believe her when she takes the oath after she gives testimony that she would defy a judge and go to jail before she'd ever do what a judge said. So, I mean, if you're going to have 2 witnesses who sink you, and I know Pecker and all the other people are real bad witnesses for him, but come on, for some of the jurors, at least 1 or 2 of them, I think it's going to come down to, what do you think about Stormy? What do you think about Michael Cohen? And if they disbelieve both of them, there never was any sex, and Michael Cohen basically was going to take care of it some way that Trump was too busy to really get into the details of running for president 2 weeks away, and then signing the checks afterwards. So it's a real hard call, Mark, but I think on balance, yes, he'll be convicted of the misdemeanors, and this juror is still out on the
serious stuff, the stuff that
I think I would find him guilty. I would find him guilty, Mark, because last thought on this, I don't think that Michael Cohen just wants revenge. I think Michael Cohen has enough corroboration. I think Trump is such a micromanager. So I think me as a juror, from what I've heard so far, I would vote guilty. But whether all 12 do of the felony charge, that I'm still waiting to see. I hope I'm not. Every commentator I've seen wimps out more than me. So if you think that's a wimp out, but I'm just not totally sure. Ask me next week.
All right. Next week it is. He's David Katz, everybody. Thanks, David. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.